Thank you very much, David. I'd like to start by acknowledging my wife, Gail, who's here, and my daughter, Meredith. We were all Hockessin residents for many years, and Meredith is a Hockessin resident today. I think I pronounced that right, didn't I? Okay, I'm one of those newcomers. Thank you for inviting me to speak today. Before there was Brown versus Board of Education, and before there were the Gebhardt cases, there was Brooks Parker versus the University of Delaware. And you students might not know this, but in 1950, we all talk about these 1952 decisions, which led up to the 1954 decision in Brown versus Board of Education. But in 1950, Brooks Parker and 6 other students who wanted to attend the University of Delaware filed a lawsuit in the Court of Chancery that sought to force their admission into the University of Delaware so that they did not have to attend Delaware State College. The reason they didn't want to attend Delaware State College was because in 1950 it had just lost its accreditation and didn't offer the same educational opportunities as the University of Delaware did in 1950. And in that case, Parker versus University of Delaware, my father found that the educational opportunities at the University of Delaware compared to Delaware State College were superior at the University of Delaware, and ordered the University of Delaware to consider the admission applications of these students without regard to race. So that was 1950. That paved the way. If you were looking at the news media and you followed my father around between 1950 and 1952 and you read his speeches during that time and his radio broadcasts, you would see a man that was passionate to change the course of history in race relations in Delaware. So students, let's talk a little bit about the 1952 decisions, and in particular the Hockessin decision. You have a sign there, it says equality. Where does that word come from? Why do we rely on it so much as judges and lawyers? Well, it comes from the United States Constitution, and I hope as part of your classes at HB that you have the opportunity to be given a copy of the Constitution and you actually read it, because it's an amazing document and it's not something all of us do, but I recommend highly that it's something that we do often. I know I do. That word equality comes from the Equal Protection Clause in the United States Constitution, and hopefully you're learning a little bit about that. But basically, the Equal Protection Clause guarantees the equal treatment of all citizens in the United States. Everyone should be treated equally. Well, those words are grand words, but our actions as a government didn't live up to the promise of those words. The law of the land until Brown versus Board of Education was decided by a case of Plessy versus Ferguson. That's a name that you need to remember in the context of Brown versus Board of Education. In Plessy versus Ferguson, the United States Supreme Court held that equality could be guaranteed African American students as long as the separate schools that they attended were equal to the schools that the white students attended. Think about that for a minute. Black students could attend their own schools. They couldn't attend the white schools, and that was constitutional unless the schools were not equal. Well, we know what happened in the period between 1950 and 1954, before the Brown decision. The schools were dramatically inferior. It was as plain as the nose on your face that that was the case. So what did the court systems do before Brown versus Board of Education? The court said, yeah, we know that the schools are unequal, but let's give the state time to bring the black schools up to the level of the white schools. Take your time, be patient, and this will all get fixed in the course of time. Well, that wasn't good enough for my father, or the Court of Chancery, or the United States Supreme Court. The unique role that Delaware played in the Brown versus Board of Education case is this. In my father's decision, he was a state court judge. State court judges aren't allowed to tell the federal judges what to do. It's called the Supremacy Clause of the United States Constitution, which says the federal laws are supreme to the state laws. So my father was not able to say to the United States Supreme Court, I overrule your decision in Plessy versus Ferguson. But he was able to make an observation, which was cited extensively in Brown versus Board of Education. And that is this observation, that segregation itself, regardless of whether black students are provided equal opportunities in their schools as opposed to white schools, segregation itself results in unequal treatment under the 14th Amendment to the United States Constitution. That was the basis for the Brown versus Board of Education case by the United States Supreme Court. There was no comparison of the different schools, the white and the black schools, the educational opportunities in one school versus the other. The United States Supreme Court accepted the reasoning of my father and his decisions in Belton versus Gebhardt and Beulah versus Gebhardt, that segregation per se results in unequal treatment to black students. What was the other remarkable thing about the Delaware's role in Brown versus Board of Education? It was this. Delaware was the only case of the 5 cases to be affirmed by the United States Supreme Court. What does that mean in plain language when we say the case was affirmed? Students, what it means is that the Delaware case got it right, and the other 4 cases got it wrong. Finally, I'd like to close with one other important thing that my father did in these decisions, which the United States Supreme Court did not do in Brown versus Board of Education. My father ordered the immediate admission of African American students to the white schools in Delaware in 1950 in the University of Delaware case, and in 1952 in the Beulah and Belton cases. He said, you should not have to wait to have your constitutional rights addressed. If they're being infringed, the remedy should be now, not sometime in the future. Unfortunately, the United States Supreme Court took the approach of what has now been termed all deliberate speed, which essentially allowed a transitory period for schools to desegregate instead of ordering the immediate admission of African American schools. And we all know how that turned out. So I am just unbelievably proud of my father and my family to have the foresight in 1950. Think about how popular my father was after those decisions. You can imagine. A lot of things that he was doing were severely impacted because of his courageous decisions in these cases. But he knew what was right, he did it, and Delaware got it right. So I'm so proud of my work at this school, and I'm also so proud of David Wilk, who's been such an inspiration to get all this done. So thank you very much, and with that, I will introduce someone who needs no introduction, Senator Tom Carper.